Just because you slip and fall does not automatically mean you are entitled to compensation in Florida. Generally, in Florida, landowners have a duty to maintain their land in a reasonably safe condition and to warn of hidden defects that they knew about or should have known about had they performed a reasonable inspection of their property. In Florida, there are additional laws that have been put into place for slip and falls that occur at businesses. Regardless of where your slip and fall occurred, if you sustained injuries, it may be crucial to hire a Florida slip and fall attorney in order to obtain the compensation you deserve.
If you are at a Florida business and you slip and fall on a substance or object that was not supposed to be there, your claim would likely be subject to the Transitory Foreign Substance Act. Some common examples of transitory foreign substances or objects that we see include liquids on the floor in an aisle of a store, a PVC pipe in the middle of a sidewalk, and a smushed grape or other piece of fruit on the ground in the produce section of a grocery store.
Essentially, the Transitory Foreign Substance Act requires an injured person to prove 1. That the slip and fall occurred at a business, 2. That the injured person slipped and fell on a liquid or solid substance, item, or object that was in an area where it did not belong, 3. That the business knew or should have known that the substance, item, or object was on the ground, 4. That the business should have cleaned up or removed the substance or object, and 5. That the business did not clean up or remove the substance or object.
Even if the business did not actually know that the substance, item, or object was on the ground at the time of a slip and fall, an injured person can alternatively prove that a business had constructive knowledge, or that the business should have known about the substance, item, or object had they performed a reasonable inspection. An injured person can prove constructive knowledge in the following ways. 1. By showing that the substance, item, or object existed on the ground for such a length of time that the business should have known about it. Or 2. The condition occurred so regularly that it was foreseeable. Thus, a business owner has a duty to anticipate reasonably foreseeable hazards and make sure they are taken care of before somebody gets hurt.